Okay, let's go. 3, 2, 1, let's go.
Okay. Hello, Mohammed. How are you?
I'm very well, thank you, Felicity. How are you keeping?
It's fabulous, thank you.
Now, the last time I saw you was, last year. Sounds far away.
It feels like a very long time ago.
So, what has been happening since then, Felicity? I know today we plan on having a bit of a recap. It's a new year, a lot of challenges. We just heard this morning that schools are reopening not on the 27th of January, but on the 15th of February. So, there's everywhere there's changes. And with regard to maintenance, I can imagine the same applies.
Yeah, I think the one thing that is certainly a reality is uncertainty. And that spans across like everything in our lives. Nothing is certain anymore. And I think within that creates a lot of anxiety for most people, because it affects like our frame of mind. It affects our physical existence. As severe as like, is our next meal guarantee for a lot of people in this country. So we are certainly living in very unprecedented times. And I think the truth is that we're having to really dig deep to find compassion and have empathy on every single level. And I know that it's difficult, and at times it's almost like contrary to what I do, and that is hold people accountable. We can't do that in an inhumane manner when we are going through a pandemic. And we thought that we would face these challenges in last year, but we're going into a second wave. And I think that it's a pretty realistic thing that we're going to go through a third wave. And what is that going to look like for all of us? Because we just can't rebuild anything while we have all of this facing us. So, how does that affect us? The reality is our people are losing their jobs. And that is the premise of maintenance, is that is affordable. So, while we've got to keep encouraging people to follow the system, the truth is that we have to also be working from a place of empathy, compassion, because so many people are dying, so many people are losing. The level of grief for people that have passed on, grief for the change in our lives, the uncertainty is huge. And collectively, I think we're all feeling that. And how do we respond to that? A lot of people respond out of anger and despair and become more despondent. So having said all of that, I mean, when it comes to maintenance, obviously not everybody is affected. Not everybody has lost their jobs. Within that, there are a lot of people who are using this to further their own agenda, whether it's to pay less money or to punish people further. That's a one-on-one case, so we still can't generalize. But I really think that we have to really be humane about a lot of the circumstances, irrespective of what has gone on in the past with our previous partners. And I hate using that saying, you can't draw blood from a stone, because for me it's cold and it's callous, and it's just we have to dig deep and find the compassion and the empathy and understanding within each one of us. Having said that, I just think that where people are caught in this situation, that the least they can do is try and get some food, which is a basic to survival. Whether it's standing in a food queue, or trying to get a food parcel, or trying to get food from your family or your neighbors, or selling some of your stuff in order to go and get food, at least make an effort to contribute to your child's survival. If anything, I mean, you've just said school is not guaranteed. You can't go to jail for not paying your school fees. You're not going to die if you don't go to school, or those are basic human rights. You're not going to die. but you're going to die if you can't eat.
And Felicity, on the point of schools, many parents, usually, this is my understanding how maintenance works, you grant the court grants a maintenance order, expecting school holidays to come to an end, at a certain time of the year, or to only be so long. Year school holidays are basically extended by another 3 weeks almost. It places a great burden on the primary caregiver. It causes problems because what happens then? The child costs much more money during school holidays, and so those are the things which I obviously cause certain difficulties with regarding child maintenance matters and the maintenance amount, because now arguments erupts, whereby the children should have been at school, and for argument's sake, other issues arises now, because once schools do start, how do parents budget going forward, especially if you lost your job and so on. So you have touched on that. Felicity, any other changes which you have experienced in the system? I have seen a lot of problems whereby people are now being COVID-19 positive within the department, within an office, and the office will have to close. When the lockdown started, when the COVID-19 started, there was an initial time where things were closed down, and then things started becoming a bit more easing. There was a bit of an easing. But I think people are seeing it more important now because people are dying more often than they died last year. And the need to close down shop is there. It's greater than it was previously. And the narrative we had last year regarding, can't government do this, can't government do that, is becoming, it's a different narrative today. Maybe they should make use of technology like me and you are making use of here, Zoom consultations and so on. But there needs to be a shift. But at the end of the day, Felicity, this is my last point I'll make on this issue, is that child maintenance needs to be paid. The child needs to eat. And we need to be creative. If government isn't there to assist us because of COVID-19, parents need to buy in, and they need to make sure that the basic needs of the child is met. It's a matter about survival now, Felicity. It's no longer an issue concerning, living a luxurious lifestyle.
The thing that really annoys me, Mohammed, is that the courts were inadequate before COVID. Okay. And now it's just a compounded to non-existent, which is hugely problematic to me. I understand. I mean, yesterday I posted a picture of a magistrate's court in KwaZulu-Natal where there was no social distancing. They were like on top of each other. Somebody just comes to the front of the queue and shouts out a list of names. There's no enforcement of protocols, which is hugely problematic. And this is the Department of Justice. Once you get inside, the place is empty. So I go, for goodness sake, it's like it was hotter in Durban than what it was in Cape Town yesterday. I don't know, there's an absolute lacking of friggin' common sense and logic. Like, it just infuriates me because, we're looking for fairness and justice, and we've got a bunch of morons, really, in some places, just like totally disrespecting our dignity, our basic dignity, which for me is that just shows how flawed the system is. And I mean, I know that it's not just a maintenance. Our judiciary needs a major overhaul, like across the spectrum. There's so many countries where this is an online process, and this was supposed to be in place years ago. Are you there?
I'm listening, Felicity. I think the signals are a bit strange. The internet connections are a bit bad. Felicity, go ahead. I'm listening.
So this is like everything else, having lived through the last 14 years of corruption, the impact that we're living with is that this stuff should have been in place. There were budgets, there were provisions for this to move things online. We would be looking at a completely different scenario now. So there's nothing we can do about it right now. But if we're sitting here, where do we get answers from? I mean, my level of frustration at the arrogance of the DOJ not engaging with civil society is just beyond me, okay? That they don't feel that they have to engage with us. But what have they learned from this? what are the remedies going forward, and what sort of timeframes are we looking at? Because this is not sustainable. I mean, we've been set back 20, 30 years in terms of resources, of everything. And the bottom line is that how are we going to keep people alive? If when we come to maintenance and our area of focus is children, there just has to be a greater commitment to government to facilitating this process of children being adequately supported by the parents that have the means. And it becomes quite difficult because yesterday I had a chat to a member, and she was saying that, so she's been retrenched during COVID. And she asked the question, so she's been taken to court now for a reduction. His salary hasn't really been reduced that much. Okay, he's claiming his salary is reduced. However, he's got a second property of which he's getting an income for. He's got several cars, and he's applying for a reduction. And she asked me, she said, the fact that I'm unemployed, should I not be asking for a variation for an increase because he's still earning an income and I'm not? So I said to her, well, that's what the provisions of the law says. And if we look at the common experience when the primary caregiver, normally the mother, approaches court, and the father arrives and he goes, I'm unemployed. And they go, sorry, there's nothing we can do. He's unemployed. And the onus is on the primary caregiver to continue providing 100%. And then the onus is still on her to keep chasing up. The moment she finds out that there is a source of income, to go back and start the whole application all over again. So the converse should actually be applicable as well. She's now unemployed. So surely, the courts should look at it and say, well, you now need to provide 100% because the primary parent is not earning an income. So she said, what are the chances of me getting that right in court? I said, well, now it's difficult because the application in front of court, and you can correct me if I'm right or wrong, is she's the defendant and he's the complainant for a reduction, a variation of order, a variation of maintenance. And she says, but he denies that he's getting an income from his property. So I said, well, the first thing that the courts should do is do a proper financial inquiry, and that they can do by a simple ITC search to see how many bonds he's got, establish those facts, and only then can they really go on and make an informed ruling. I'm going, but the reality is the chances are that's not going to happen because, and this court, I know, I'm not going to mention names, but I know that this court has a very adequate maintenance investigator, and they're mandated to do this. But because it sounds like too much work for them, and I understand that almost every maintenance case should actually go for a financial inquiry, we know this. So they select the worst ones. But is there a guarantee that she's going to get that right? That they're going to say, okay, we'll take this to a financial inquiry. I then said to her that the provisions of the Maintenance Act state that if you have assets, that you've got to liquidate those assets to be able to support your child. Again, how many rulings have we ever seen where the person responsible for paying maintenance has actually disposed of assets to realize cash to be able to support their children? This is in the Maintenance Act. So here I am trying, so this is a problem. These are the provisions in the Act. This is what I'm advising her. $1 million question. Is that what is going to happen when she appears in court?
Won't happen, Felicity, it won't happen. We had this problem before lockdown, and I think this problem was much more worse now during lockdown. And it's very, very, very sad. And you are 100% right. She's entitled to make an application for a reduction of maintenance, or anybody's entitled to make any application, and the court will have to look at all the facts and make a fair decision. even if you did not make the application and the court believes it's in the minor child's best interest to increase the amount of money or decrease it, the court will have to do that. But Felicity, that's a problem with me. You know, people.
Sorry, can we just get clarity while we're talking about that? So if he's made the application for variation for a reduction, and this is only in front of the maintenance officer, this is not in front of the magistrate yet. But if it were to get in front of the magistrate, is it legally possible for the magistrate to look at the evidence in front of them and make a ruling to increase the maintenance, or does that have to be a separate application? Because here you've got a defendant and a complainant. So does a magistrate change it around and possibly increase the maintenance when they look at the facts before them?
The
or is it a separate application?
No, the obligation upon the maintenance magistrate is to make a fair order, considering all the facts. So if it is fair and only proper, for argument's sake, let's say the child costs 1,000 rand per month, but the mother is asking for a sum of 100 rand per month. Although an application is for 100 rand and the father can far exceed affording 1,000 rand, the court will not grant 100 rand per month. The court has to grant an amount of 1,000 rand per month because the child costs 1,000 rand per month. Although she's only asking for 100 rand, or she made an application. So the same applies to the converse as well. If the other party is applying for a reduction or an increase and the court looks at all the factors, the court will say, no, I see what the application is, but a proper maintenance order would be to pay either for the father to pay more or for the mother to pay less. Whatever the case may be, the court is not bound by what the parties are asking for or what they are not asking for. So if you look at the Maintenance Act and the law doesn't say that the order can only be as per what the party is asking for, or the maximum as what the parties are asking for. It has to be a fair amount. That's full stop.
Okay. I get that, but my question was, so this is an application for reduction. So can the magistrate turn it around and increase it, even though it's an application for reduction?
Yeah, so the mother will have to ask, technically also ask for that. I mean, they will have, obviously Felicity, there'll be discussions and speaking. The magistrate will have to, once the mother comes and she leaves evidence. So after all that has taken place, the court won't just automatically, if the whole flavor in the court was going one direction, and all of a sudden the court is, and the court's questioning was going in one direction, and when the judgment comes in, the judgment is totally a different direction. If the mother says, I do not need more money, or I do not require more money. I'm trying to give a general understanding of the facts over here. So, under your situation, the magistrate will ask a question. Alternatively, although there is not an application, the mother will have to speak up and speak about the issue she has, and speak about the problem she has. So the court will have to look at all of those things. Because many times it comes, it will be only fair for example, for the father to pay towards school fees. But the grandfather pays for the school fees, or the auntie pays for the school fees out of their own. So there's no need for the court to make an order now that the father should pay the school fees amount of money towards the mother. So Felicity, my answer to your question would be that the mother will have to speak up. Although she never made an application, she will have to say these are. At the end of the day, the court will have to be convinced that whatever decision it makes, it must be fair based upon both sides, having heard both sides. Felicity seems quite hot that side. The temperature in Cape Town is quite low. It's drizzling outside. How's it that side?
Sure, it's very hot, I tell you. Okay, Mohammed, I just want to, so I hear this often, is that when it does get in front of a magistrate, that when the primary caregiver tries to voice or bring to her attention of a particular set of circumstances, that she's often told to just keep quiet and she's not heard. And for my understanding is that the prosecutor is the person who should actually be representing the child. They're almost like your legal person who's supposed to be acting in the best interest of the child, really. But they don't seem to interject, and the magistrate, we see this so often in the group where they say they try to speak to the magistrate and they are completely silenced or told to shut up. If they become emotional in the stand, they're told to stop being emotional and to they will just make a ruling against them if they can't pull themselves towards themselves. I mean, there's just so much poor treatment of people when they actually get there. And I mean, I for the life of me, don't understand what kind of training that these magistrates have, or is it their ego? Is it that they just see themselves like so omnipotent that and insensitive, and really not being fair and just to law? Because I mean, my understanding in the Constitution and the Bill of Rights is that everybody should be treated fairly and be given due access to law.
No, Felicity, you're right. The problem we have is that there's a few thousand magistrates at least, and we only get the problematic things on our groups in our chats. There would be maybe like 90% of the magistrates who do proper judgment, proper rulings. And the unfortunate thing is, one party will always be unhappy with the magistrate's decision, and that is generally the person that complains. So I do not want to be generalized here and say all magistrates courts are that way. No, we have many very good magistrates courts, at least in Cape Town, that listen to both sides of the matter.
So mine is okay. So these things happen, and yes, not all magistrates are bad. These amazing magistrates, these amazing maintenance officers, prosecutors, but obviously, and as you said, we become aware of the complaints. We also there's been a lot of acknowledgements of good magistrates, but we're talking about what do we, so if a person is in the stand and this is happening, how do we empower people in that situation to be able to navigate that? I mean, this is what our video is about. How do we empower somebody in that particular situation to navigate? If it's all now over and that person feels it's unfair and there's enough like kind of data or information, evidence that it wasn't really that the magistrate had a really bad day or whatever it was, what is their recourse? I mean, this is what it is. Let's give them, it happens. We've seen it happens. And then when the complaint does get there, then it's investigated properly, and hopefully they look at the facts and go, or get another magistrate to have it reheard or whatever. What is the recourse?
Yeah, so the recourse is obviously an appeal. So the law is clear. The magistrate will have to, and it done an appeal, I think, in Graham Sound last year, 2 years ago, regarding the specific issue. There's an obligation upon the maintenance magistrate, and the maintenance officer to properly investigate and inquire into the matter before a final ruling has been made. So they must do their job. So let's take one step back, Felicity. My advice to anybody: when you go to the maintenance court, it's very important. Don't presume anybody's on your side, or presume everybody's neutral and biased. I think that's a better way of putting unbiased. So they're not on your side, they're not on the father's side. You need to go to the maintenance court, not only, and I'm being very frank here, not with a mouthful of teeth. You need to go to the maintenance court with a folder and saying, this is my information, this is my evidence, and you need to easily unpack it and make it sound logical. Don't expect the maintenance court or the maintenance office to understand it or to follow you in what you are stipulating. So that's very important. So that you need to present to the maintenance court as best as you can. They won't do that for you, or more than likely they won't, based upon our complaints. But if you are unhappy with a maintenance court's decision in a maintenance court matter, the only thing you can do is to appeal to the High Court. There's nothing else you can do. It won't be heard again by another maintenance magistrate. Only an appeal can take place.
Okay, so my understanding is that if you did not sign it, okay, in the magistrate, if you did not consent, okay, if you did not come to an agreement, then you can appeal, okay, within the lower courts. However, if you consent to an amount and then afterwards you come and go, I'm not happy, or this wasn't right, or that wasn't correct, then it has to be a proper High Court appeal, because it was by consent. But if the ruling was not made by consent, my understanding of the Maintenance Act is that you can then approach the Magistrates Commission and get another magistrate to look at the case.
No, Felicity, no. Once a matter has been finalized,
yeah,
evidence has been laid, the magistrate heard everybody, you need, and a decision has been made. That is the maintenance order. That is the order. And that order stands unless, in terms of the Maintenance Act, there's a change in circumstances, so you can make an application for variation or substitution of the order. But if you are unhappy with the magistrate's decision, and you're saying, based upon the current facts, he made a mistake, you need to appeal to the High Court if there's nothing else. You can't have it reheard, rehashed again. There needs to be finality on the matter. It means tomorrow fathers or mothers will be called to the maintenance court every day because, like, you're going for them shopping. You're looking for a different magistrate to give a different decision. That doesn't. The law shouldn't work that way. A magistrate gets appointed, and he makes a decision, and the law spoke.
So I mean, yeah. So then the option is to what? Wait 6 months or a year and then apply again.
But there needs to be a change in circumstances. You can't go to the maintenance court on the same facts as previously presented to the same court, and saying, now I wanted my year, but on the same facts I want you to relook the matter. There needs to be a change in circumstance. Either you lost your job, or the kids went to high school, or the other parties earning more money, and so on.
Okay, but this is the reality. Okay, and we see this. So a primary caregiver, the mother goes to court, and not a fair ruling is made, and an amount of 750 is made when the parent is earning 25,000 Rand a month and has the means to pay, but because they had legal representation or whatever, and the ruling was made 750 Rand. I mean, surely you can go back in 6 months or a year and apply for an increase without a change in circumstances, because logic tells you that you can't raise a child on 750 Rand, or, at most 1,500 Rand, and the other person has the means. I mean, for me, it just sounds so unfair, because if your only recourse is High Court and you're only earning 8,000 Rand, how do you challenge this in High Court if you don't have the means?
But Felicity, let me pose a question. I mean, the legal system is structured in a certain way over the last few hundred years. So you appear before magistrate A, you argue your matter, your evidence. Then 6 months later, you appear again before magistrate A. You argue the same things. His decision will be exactly the same. Well, what are you arguing different before him? You are still saying the father 25,000 per month, and so on. Magistrate A made a mistake made an error in his ruling. A higher court needs to look into that specific matter and to decide whether or not he made an error or not. So the higher court will go through all that evidence. You can't. Unfortunately, I mean, I would like to have a relook in the matter. The same way with High Court Rule 43 applications. You can't go 6 months later on the same facts because you are unhappy with the previous magistrate's the previous judge's decision. On the same facts, and there's no material change in circumstances, and asking for a different amount of money. There needs to be some type of change in circumstances. So unfortunately, that's the way the legal system works. If a ruling has been made and you're unhappy with that, you have to take it on appeal. Unless there's a change in circumstances, then you can come back to the maintenance court.
I know, you see, that for me is like hugely problematic, because it's not, I mean, and I'm working on a particular scenario. I'm working on a particular that is completely and utterly unfair. And for whatever reason, that magistrate just made that decision, whatever. I mean, and whether the person erred or it was intentional, or their own interpretation of the evidence in front of them, to a complete lay person, you would go, but that's so unfair. For me, it's even more unfair that there's no affordable way to readdress this, because in a year's time, there's no change in circumstances. For me, it just collectively, how do we change this whole inequality of women, particularly carrying the financial burden of raising children? Because for me, this is a lot deeper. Okay, this speaks directly to the oppression and poverty of women and children. And I mean, I'm harping on this because this is a very classical example of how do we interrupt, how do we change it? Because it's not just a decision, it has such greater impact about the inequality, the inherent, this hierarchy of power and dominance that, so how do we break it? How do we interrupt it? Because it comes down to money. It comes, because I can't afford to take it to High Court. Well, that's just suck it up, buttercup. It's just the way that it is. Life's unfair.
But listen, it's the same scenario. For example, let's say you've been found guilty of murder, for argument's sake. You're somebody that's found guilty of murder. You're not happy with the judge's decision. You go 2 months later back to the court and we have a retrial. That's the finality of any decision. So you're presiding off. That's the way that the legal system is structured. I know it's unfair. What if somebody being unfairly found guilty of a crime and you go to prison for 20 years? You can't afford a lawyer. You have to stay in prison. Felicity, I think attacking the legal process won't help us much because that is the way it's been always been done. Maybe the legislation can come on board and say on all maintenance matters there's automatic review from the High Court. I heard something like in the past where the High Court can review matters, but I don't think there's automatic review whereby a magistrate makes a decision, automatically the High Court will look and apply that. Maybe policy like that can be in place. But for the pragmatical aspect of having the matter reheard with no new facts, it means every day the same dad, he applied for deduction today, court didn't grant it, 6 months later he applies for deduction again. So the parties are in the High Court all the time on the same facts, arguing the same points in the same magistrate. It won't take us further. That's my view on the matter. But Felicity, tell me, what temperature did that side be?
And
It seems very, very hot
sorry?
there. It seems very extremely hot there in Durban. Are in Durban now?
Why would I be in Durban?
Oh, I thought you were in Durban when you spoke about the court early on. My apologies for that. Okay, go ahead.
No. It's just humid here, where I live. And of course the doors and that are closed so that I can block out some of the outside noise. So it's just like really making it warm. And besides that, I'm pretty hot. I'm just teasing. But it's just that, and I really don't mean to be harping on all of this, but part of people that are watching these conversations that we have relate to them. And we can't just go, and I know that this is your profession. For me, I'm the disruptor, I'm the agitator, I'm the person who's looking for the problems that we can try and change in the future, because everybody can resonate to this. And for me, the deeper issues are that's why people intentionally resign from their jobs. This is why they disappear, because or they don't even go back to the courts because of all of this dysfunctionality, or that turns into absolute and utter perceived and real unfairness. But we can sit and talk about the law. The law's there. People can download the Maintenance Act and whatever. What they don't have access to is the meaty stuff like this to understand it. Because when we say to where there is all of this stuff, and yes, there is room to introduce a bit of law reform, to look at things differently and issue different directives, because we know that a lot of these courts are issued directives on a framework to operate. Like, these are our resources, our budgets have been cut, so now this is how we're going to navigate this, and here's the directive for that. We know that that's how it works. But for us as civil society, we need to understand what it is, because when we understand and when we have context and the level of inability to enforce or to understand or to make a difference in our personal capacity, is to understand why we actually need to come together collectively and go, we stand together, and this is not in the best interest of the child or whatever, and collectively lobby for some kind of review or commission of understanding, inquiry, whatever they want to call it, because you can jump onto a Facebook. There's so many maintenance groups. You see the conversations everywhere, every day, about just how messed up the system is. So, we can keep complaining about how messed up it is and put the responsibility on somebody like myself, because I'm an activist, to bring about change on my own. It's impossible. It's absolutely impossible, because when we do have a call to action, whatever that is, whether it's signing a petition, whether it's sending in complaints, whether it's giving information, whether it's showing up for a protest of sorts, show up, participate, because then they can see that there are loads of people that are not happy, not just one or two or three or four lone voices. They're not sitting on Facebook, like going through all the groups, going, oh, I feel so bad, they've insulted the DOJ, let's fix this. They don't care.
Felicity, I agree with you on that. Felicity, on that point you mentioned earlier on, maybe from a foundational point of view, the Department of Justice needs to properly train maintenance officers and maintenance magistrates. There is no need for the High Court, there's no need for an appeal, because if the magistrate made a proper decision, he applied the law properly. There's a few case law, there's case law applicable, they can study the cases and they know their job. So if the magistrate do their job properly, the maintenance officer and the maintenance investigator does their job properly, and obviously we presume a proper ruling would be made in either event. But Felicity, we like the fact that you are, the stickler, the person that causing all this anarchy in the maintenance, with the Department of Justice and within the law. We appreciate that, and we need someone like you, because if you're not there, the conversation won't take place. And many people get energy from you. They obtain some type of guts, because if Felicity and guests can do this, can talk against the Department of Justice, why can I not? But I would also advise people, if you see a magistrate and you know of a magistrate or maintenance officer or investigator who is lazy, who is unfair, who is improper, please write to their bosses, complain against them. So if we have this magistrate that thinks he's, this boss attitude, where he believes he's the judge of the specific area, and he has a nonchalant attitude regarding maintenance, write to his bosses about it, complain about him. I think that will cause some type of change, whereby either he changes his attitude, or tomorrow they'll have to replace him.
Well, it's also, yes, it's hard. It takes effort. And I mean, that's a whole thing for me when I coach people is, it's about taking personal responsibility. If you're unhappy with anything in life, if you're unhappy with the process, how are you going to gauge how disenfranchised you are? That's by becoming informed. So read the Consumer Act, for example, if you're unhappy with the way that a shop has treated you in terms of goods you've bought. But read the Maintenance Act. Yes, it's difficult as a layperson, because there's a lot of cross references to certain sections that become quite confusing. But by and large, if you read the Maintenance Act, you can get a clear understanding of what the legal framework is, and how to expect or demand. I hate you, but to get fair treatment is to print out a copy of the Maintenance Act. Your personal circumstances, whether it's arrears, whether it's criminal, civil, first application, you will find the particular sections in the Maintenance Act. Highlight those, so that when you go, not from an arrogant point of view, because we're not legal people, but to raise this and go, hang on, this is what the Maintenance Act says. You are diverting or from this particular thing that it makes provision for. Can we get clear on this? I don't understand it, because this is what the Act says. The Act says proportionate to income, yet you're insisting that we pay 50-50, for example. And that's what it is. It's becoming informed, because then you can participate in the process instead of being passive. Because but you also then have a better chance of getting a better outcome, because you're participating. You're not just passively sitting there getting a ruling made because you've not participated and then complaining afterwards. That's what empowerment is. For me, it's about acquiring knowledge, using it for a different outcome. And that's what I do.
I like what you mentioned.
You need to do.
I like what you mentioned now about participation. Participation is very important. Don't just go to the maintenance court and sit back. As I mentioned earlier on, you need to actively partake in the system. The Maintenance Act, yes, we might have some debate regarding the strength and power of it, but there has been some recent amendments, and I think if you know these amendments, for example, like you can obtain details from a credit provider, from a cell phone provider, and so on. So if you know the Maintenance Act before you go to the maintenance court, or some commentary, you watch a few of these videos, you read some articles online, etc. So you go to court more empowered. So when you do engage with the maintenance officer, the maintenance court, they know they're not dealing with somebody they can just play around with. They're dealing with a complainant that understands the law and so on. Felicity, we have a question, a quick, simple question on the Facebook Live chat. I think I'll just read it out quickly and we can move on. Is that fine, Felicity? Quickly.
Sure.
It says, yes, I have a garnishing order. How does the yearly increase work? Who applies for the increase? I'll give a quick answer to that is, unless the maintenance order that was garnished deals with an increase, an annual increase, either 10% or CPI. If it deals with that, automatically the employer will have to pay the increased amount on a yearly basis. If no mention is made about an annual increase, either 10%, generally 10% or CPI, then you'll have to apply to the maintenance court every year for an increase. That's unfortunate. So we always advise people, please try to put in an amount so you do not have to come to the maintenance court every year for an increase.
I mean, like, I just, like, whoever is hearing that, that's exactly what they do, because they know what that means. It means going back to court. It means getting the other person summoned. It means a new garnishing order. It means being served. That could be 9 months down the line when you're ready for the next increase again.
But listen, I believe in a maintenance matter, the bare minimum the court must include in a maintenance order is CPI. There's a bare minimum because that's technically a fair amount, with inflation and so on. The bare minimum. But for a court to stipulate nothing, that shouldn't work. Alternatively, the court can say, and why is the burden upon the complainant? I mean, let's put CPI, let the other party come to court and say, I can't afford it. And then we can spend 9 months.
It should be standard for every single maintenance agreement, whether it's by agreement or by order. It should be compulsory in every single maintenance agreement. I mean, it's just, that's like one of the things that I speak of. Because who does the onus fall on? It's the emotional as well as the physical labor that one has to go through to be able to enforce. Just on that, slip my mind now. Okay, I'll have to think of it again. It was quite an important one, but now I can't think of it. And it comes with gone through are quite problematic. One, my understanding, and correct me if I'm wrong, is that if the person just resigns and the employer does not notify the court, then that employer can be held responsible for the amount that they should have paid. And also, there is a consequence to them not informing the court that that person has left, as well as on the person who's been garnished. I mean, because the Maintenance Act says that within 7 days, they've got to notify not just the very least the courts, but the other person of change of circumstances, which could be home address or work address. But because that's not enforced, it's like the norm. People get resign, you only find out like 2 months later, or when the money's not being paid. Again, you know, all the labor that you're having to do to phone the employer. Oh no, he's been, oh my gosh, no, he's not working. Did he get a pension pad? Now that's another whole rabbit hole to go down, to go and try and get outstanding maintenance plus future maintenance, because are they going to get employed again? Then they don't tell you where, then you've got to run around and try, you know.
It's ridiculous, Felicity. Felicity, quick comment quickly. My son was off when I made an earlier comment. My earlier comment was basically check up on the employer all the time to make sure that the person is working. They don't get surprised. Felicity, my son is back on. One question we have, another question. I'll just go with this to this quickly. My daughter's dad gave in a thing saying his expenses are 21,000 a month, including his bond. He said to the buck, he also claims that he only gets 6,000 as salary. The rest gets substituted by his mom, that also his business partner or boss. How do I go around this? So basically, the dad is saying his expenses for the month is 21,000 rand per month. He earns 6,000 rand per month, and his mom pays the additional 15,000 rand per month. I mean, we all know that is not true. It's playing, the system is playing the game. What needs to happen over here is, when the maintenance inquiry gets heard, the mother must come to the maintenance court. The books of the maintenance of the business needs to be outlined clearly. If they're playing the system over here. Clearly, he's just stipulating his earnings 6,000 per month, but his actual income is much more than that. So it's very easy for me to do that. I can own a business. I can have a business partner. I can be putting a lot of money from the business because the business is earning that amount of money. But when I ask my accountant, please draft a pay slip for 6,000 rand per month, that is unfair. So you need to subpoena the accountant. You need to subpoena all the documents of the business. We have to look at this business holistically, completely, and then you will be in a better position to determine whether or not it is 6,000 per month that is earning or not. Felicity, any comments on that?
Yeah, no, absolutely. But yeah, I hate being the doomsayer, but I'm not going to sit here and give anybody the illusion that that's happens, because it doesn't. They just don't have the capacity. Which actually, I remembered what I was going to ask you earlier is, so the maintenance investigator is mandated to do a proper financial inquiry and go and establish what the reality is. Is there provision in the law for the complainant to get a private investigator to get all of that information about from the company? You know, if somebody has their own business, to do all of this and take it to court as evidence. Does the court take it into account if you, without a legal representative, present them all this evidence, or does it have to be done by the investigator?
No, Felicity, you're entitled to present your own evidence. Obviously, it needs to be, you know, in terms of the Law of Evidence Act. It can't be like hearsay evidence. So you can't just come here with a piece of document stipulating that this person is earning 10,000 per month and it's not verified. It's only a piece of document. He will obviously oppose it. So you're entitled to get your own investigator, which obviously costs some money, and he or she can do the necessary investigations. You can call the investigator in as a witness, which is probably the most effective way of dealing with the matter. And the investigator can come on the witness stand and testify. I have followed this person. I've seen how this person operates. He works in this expensive area, that expensive area. He works late the evening. I saw the type of clients he's dealing with. So if he's saying he does not earn any money and is unemployed, it does not make sense. He wears flashy clothing. I saw him walking into Hugo Boss at the waterfront, or at this expensive shop here at the Canal, wherever it is, buying expensive clothing. So that is what the investigator can do. And it is his testimony to the court. He can say, I done certain searches on him. So that is fine, you're allowed to do that, Felicity. The only challenge is, it's very expensive. It costs a lot of money to do. So if you have the money, go ahead. We do not have the money. We reliant on the maintenance investigator.
Okay, thank you for that.
We try to work on 1 hour video consultations, video chats. And we're going to an hour. Any final words on your side, Felicity? Any advice to everyone? It's 2021. Lockdown is continuing. Any advice on how to deal with maintenance difficulties?
Well, first of all, I'm still going to say it, is that we really have to be empathetic, and we have to be compassionate And it's about, that's our feeling, that's our emotional response. And then go, okay, so I've now assessed the situation. I can carry it a bit longer because that's what I choose to do, or I'm not because I can't, or I'm not because I'm not going to, and then follow due process. But it's like we're having a tough time. All of us, most of us are impacted on some way or the other. And before anything else, just be human and then take the necessary actions, because we've got to come out of this somehow or the other. And that depends on how we conduct ourselves. Us showing empathy and compassion to other people is about us. It's not taking away from us, but it values who we are as human beings foremost.
Thank you for that, Felicity. Felicity, I might have, sorry, I have one or two words I want to just mention. It is lockdown, things are different. If you are supporting your child more than you believe you're supposed to, and you all know that what's happening in the maintenance court's a bit harder with it, please record things. Record. I cannot emphasize it any more. So if you are looking after your child for additional 2 weeks now because of the 3 weeks of the schools opening later, and you are incurring certain expenditure and you can't even hold the other party, whatever, record it. So when you do approach the maintenance court in the future, you have some type of record. You're saying, shoo, I had to take the following loans, I had to incur the following debt, I had to pay so much more money for the minor children's this and that and that, I had to spend more money on data and food because of this. Clearly, and the other party kept on paying this amount of money, which he always paid or she always paid. Have that information, so when you do approach a maintenance court, you have some, ammunition. It's very easy for months to go by. The lockdown is now taking place for almost a year. When do you start? So please start as soon as possible. Felicity, thank you for your time. I appreciate it. And next week we can touch on some other topics, but I always enjoy chatting to you because you are on the ground level and you can tell us things the way they are, as opposed to how we believe or presume it is. So thank you for that, Felicity. Keep up the good work, keep up your activism, and hopefully 2021 will be an exciting year for all of us, and especially for you.
Thank you, Mohammed, and the same to you. Next week, if we just put it out there now, I would really like to start going through the forms that are required to be filled in that court, so that we can, whether people need to use them now or need them in the future after COVID, at least they have a better understanding of the forms. Yeah. So I'd like to start doing that next week.
So we can start next week. We can have it on the screen as well. So if I chat about it or you chat about it, you can see it, and the people watching the video can see it as well. We can start with the maintenance application form, and then that's generally the main form, and the second form would be the application for variation, a reduction or an increase in maintenance. So we can do that on the next one or the third one. No, we'll do that. Wonderful, and we're looking forward to seeing you all next week again. Felicity, have a wonderful day, and to all the participants.